Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon. All right, we're ready to start our C calendar. All right, ladies and gentlemen, good afternoon. Okay, I was going to say don't see. All right, I see the ASGs. Gotcha. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we are going to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. We'll be providing a reset date for SAP. And Mr. George, do you know that date? 12/29/22 will be that reset date.
Is courtroom too on, Judge?
Oh, I don't see them.
They're locked down. They're locked.
Oh, there they go. Could you all hear me? I see 3. Thank you for reminding me. Is courtroom 2 there? Because I may have to say a little bit of this all over again.
Yeah, we here. They heard you, Your Honor. We're here.
Could you all hear me, or do you want me to give those?
No, they heard you, Your Honor.
They heard me, good. Glad they could hear me. So let me say this, the reset date is 12/29. And I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to also remind the defendants that you do have a right to remain silent. Anything that you say about the facts, circumstances, and the occurrences of your case can and will be used against you. The prosecutors are here and listening, so listen to your attorneys. Also want to remind you that you have a right to counsel, right to representation at this time, and most of you know who your attorneys are. All right, we'll get started in courtroom 2, I think, Arthur. Just tell me when you want to start.
Position 15.
I'm sorry, I didn't hear you.
You said 16?
Position 16, 1-6.
1-6, okay, okay,
Is that Spike?
Stockton.
What's the name of the defendant?
Stockton
I think it's gotta be Spike.
is not.
Sunbury.
What's the name of the defendant, please?
Miss Sunbury, Sumbry, Sunbury.
Oh, 17.
Oh, Sunbury. That's position 17 on mine.
Oh,
It would be conflict case, Your Honor.
Okay, conflict case, do we have one?
I think she has a private attorney. Michael Sterling.
Oh, Mr. Sterling, I see. Mr. Sterling,
Yes, Your Honor. I'm sorry, Judge. I
it's okay.
was on mute.
All right, your private counsel for Miss Sunbury.
I am, Your Honor.
Okay, all right, we're going to start with that case. And that is 22 CR 008285C. Ms. Sunbury is charged with 1 count of terroristic threats and acts. The offense date is 11/24/2022. Pretrial,
All I have says first arrest.
first arrest, right? All right, ASG Campbell.
Yes, Your Honor. Naomi Campbell on behalf of the state. The facts as alleged for this defendant are that on the date of November 24th of this year, at the location of 5474 Oakley Industrial Boulevard, apartment 631, officers were dispatched to that location for a call for a person with a hammer. Upon arrival and doing further investigation, they did learn that this defendant did threaten to cause bodily harm to the victim in this matter, Miss Angela Luckett, via text and voicemail. The officers were actually present to see the text come through in the voicemail. They listened to it as well. I won't say the specific words that the defendant stated to the victim, but I will state that she did threaten to beat her up. For that reason, the state's recommendation for bond is actually a $5,000 signature bond through pretrial services. And that's in light of the fact that she has no prior history here in Georgia, as well as a stay away from the incident location, 5474 Oakley Industrial Boulevard, apartment 631, as well as no further contact with the victim, Miss Angela Luckett. I will note for the court that we have had contact with the victim, and she does state that she doesn't want any contact with this defendant. And just for the record, the defendant did say to the victim, "I'm on your head, ho, I'm gonna beat your ass," in relevant part. Nothing further.
Mr. Sterling?
Yeah, Judge, the fact's a little more complicated than the state makes it seem. My client, Miss Sunbury, was defending her daughter, who had been the victim of several beatings by the complaining witness in this case. Judge, as mentioned, my client had no priors, has never been arrested before in her life whatsoever, is an outstanding citizen of our community, a business owner, lifelong resident of the city of Atlanta, mother to 2 children, one of whom had been the victim by the complaining witness in this case, and she was acting in defense of her daughter. What we would ask for, Your Honor, is a signature bond based on her longstanding in the community. She's a resident of Fulton County and has lived here her entire life. And again, Your Honor, never been in any trouble whatsoever, and is a business owner in this community.
Your Honor, if just briefly in rebuttal, she does have a history out of Milwaukee. It's remote, but one of the prior charges that she has is intimidating a witness. So it's not entirely true that she doesn't have a history. She just doesn't have a history in Georgia. But the state is fine with a signature bond.
All right. I'm going to grant the $5,000 signature bond through pretrial. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a stay away from 5474 Oakley Industrial Boulevard, apartment 631. I'm going to order no further contact whatsoever with Angela Luckett. No contact via email, social media, any sources through third persons, to make sure that's very clear that she's not to be contacted through you or by you, Ms. Sunbury. And I'm going to order the one-day lingo awareness course through pretrial. And I think that's it. Anything else, counsel? Did I need to
No,
take-
Your Honor.
Nothing further from the defense, Your Honor.
All right, that will conclude this case.
And may I be excused, Your Honor? This is my only case.
Okay, yes, you may. Thank you.
Thank you, Judge.
Your Honor, if I may quickly inquire with courtroom 2 as to whether or not they received the plea paperwork for position 8.
Okay.
Courtroom 2, do you have that paperwork?
I'll have Officer Norris look into it.
Okay, I'll send it to Norris.
Okay. Good afternoon, Judge. Whenever you're ready, we have Mr. Daniel Derrickle.
Okay. Okay, gotcha. Position 3. This is,
Somebody else's position 3, so they just didn't number his case. His position 3 is Brittany Gibson.
It's 3 on the count.
So I just read these numbers up here. One of those counts had like someone had twice Reese.
okay,
So it's position 3 on our count.
okay. I think we're at a different number. But this is Daniel Cole, correct?
That's correct, Judge.
You may have two different numbers, but we'll just go by the defendant's name, Daniel Cole. It may be 3 or 4, depending on which calendar you have. And I have this as a warrant EW number, or?
That is correct, Your Honor, and I can explain that further.
Okay, 0387008, charged with involuntary manslaughter. And the offense date is 12/12/2022. Do you want to go before pretrial or you want pretrial to go?
Pretrial can go ahead.
Okay, go ahead, pretrial.
This is the 8th arrest. Last was 2017 DUI, 2012 FTA for theft by receiving. The FTA was not prosecuted. 2011 probation for trespass. 2011 theft by receiving, Lowe. He got a burglary conviction conviction from 2011. That's 11 SC 102594. 2011 trespass, pled Lowe. And a 2010 trespass that was dismissed.
All right, Deputy Falk.
Yes, Your Honor, and just to clarify a little bit, we recognize that he was given first offender on that burglary possession of firearm during commission of a felony that appears based on our GCIC to have been sealed in 2017. On this case, this incident happened December 12th of 2022 at 9:25 p.m. Officers responded to 7100 Old National Highway, which was the Shell gas station. Just to explain, when they arrived, there were actually 2 vehicles parked at pumps number 3 and 5. Both, however, were bronze Chevy Malibu. So same make, same model, same color vehicle parked at 2 different spots at the gas station. When they went to observe the video footage, they saw the victim who arrived with his pregnant girlfriend. She was the driver of the vehicle, and then Trayvon Dunaville, who is our victim, Trayvon Dunaville, had gotten out of the car and went inside the business. It appears he purchased an item and then came back outside. As I'm sure many of us are familiar with, when he came back outside, there were 2 vehicles, same make, same model, same color, parked 2 spots apart from each other, and he went to the wrong vehicle, thinking that that was his girlfriend's vehicle, and opened the passenger side door to get inside of the vehicle. Upon opening the passenger side door, and this is in the surveillance video that the police recorded, that the police downloaded, and we have possession of. When the victim tried to get in the vehicle, the defendant immediately shot him. Shot him approximately 3 times. After speaking to police, it appears Mr. Dunaville was shot 3 times by this defendant, although he did fire his gun 4 times. He had a 9mm handgun. Mr. Dunaville from the video didn't even get into the car. He didn't even make it inside the car. He opened the passenger side door, went to put a foot in, was immediately shot multiple times. He then fell to the ground. It is then seen in the video that the defendant gets out of the vehicle and goes to the back of the vehicle, and Mr. Dunaville's girlfriend immediately comes to assist and render aid to her boyfriend. He did pass away. He was taken to the hospital and was declared dead at the hospital. I just wanted to tell you a little bit about Trayvon Dunaville. I have had a chance, and our victim advocate has had a chance to speak to the family. They wanted you to know that he was loved by anybody who came into his presence. He attended and graduated from Riverdale High School, where he played basketball. He attended church every Sunday and would bring friends to church with him. Trayvon had never been in any trouble, graduated from Atlanta Metropolitan College, and worked at a Dick's Sporting Goods distribution center at Camp Creek. Per their family members, Mr. Dunaville had just gotten off from work when his girlfriend stopped at the store. His girlfriend is pregnant with their first child. She is 7 months pregnant. He accidentally went to the wrong car, which again, all of the evidence shows nothing contrary to that. And he was shot multiple times by the defendant. We are having this case reviewed for felony prosecution. We have already referred the case to the DA's office. They have all the materials. As of yesterday evening, we had to scramble, get the videos, get everything. It's approximately 25 videos that they have to review and go through. However, at this point, because of Riverside, we are now forced to go forward with this bond hearing on a case that, in the state's opinion, is clearly a felony. We have referred it as a felony, and the DA's office is very carefully considering this case as a felony. We do have the family members of Mr. Dunaville here, and they would like to speak, which is their right under Marcy's law. But the state is very concerned about this defendant's history. He did have that possession of firearm and burglary case where he was given the option of first offender and did complete. He had a 2010 criminal trespass, a 2012 theft by receiving. He had a 2011 probation violation where he was confined for 6 months, a 2012 FTA, which shows a likelihood not to come to court, and then that 2017 DUI. And most importantly, and this cannot be lost on this, a man is dead due to what I believe is the haste of which the defendant acted, to a situation in which many of us have found ourselves in, where we have walked to the wrong car and grabbed the door handle thinking it was our car because it was the same make, model, and color as our vehicles. And so the reaction that this defendant had to an innocent mistake has left a man dead and left a pregnant mother without a father for her child. And so the state's recommendation in this case is a $100,000 surety bond. We are asking that he stay away from the Shell gas station that's located at 7100 Old National Highway, and that he have no firearms, and that he be forced to surrender any firearms he does have to the Fulton County Sheriff's Office. Your Honor, I am regretful that we are even placed in this situation. Unfortunately, the DA's office could not review the material fast enough for this to go to the DA's office where it should be located and where it should have received no bond. But this is the bond that the state feels is reasonable given these particular circumstances. That's all from the state.
Okay.
Judge, this is Rose Woodbury for Mr. Daniel whenever the court is ready.
All right. I still was looking at the wrong courtroom. I'm sorry, courtroom 3. Go ahead.
Yes, Your Honor. So this, he is charged with involuntary manslaughter. It's a misdemeanor. The reason he is charged with a misdemeanor is because he was sitting in his car on his phone at this gas station, and somebody, a complete stranger, opened his car door, and he thought he was about to be the victim of a carjacking. It was a very reasonable belief. He did not know this man. It's very unfortunate what transpired, but given the circumstances, his belief was reasonable, which is why he was only charged with a misdemeanor. He is entitled to a bond because it is a misdemeanor. I will also point out that we are right up against 72 hours that he's been held without a bond. So we are up against a Riverside issue here, as the state raised. To go through some of the bond factors, Your Honor, Mr. Daniel, he is gainfully employed at Kraft. It's a factory. He is a lift chart operator. He lives with his mother in Riverdale and his 4-year-old child. He's born and raised in Atlanta. I will highlight for the court that FTA is 10 years old, and that should not be held against him. Also, because he's first offender, he is not a convicted felon. We're asking the court for a signature bond, given that he's been held without a bond for almost 72 hours. That is our request today.
And Your Honor, I just again want to point out that we do have Mr. Christopher Dunaville here, the father of Mr. Dunaville. I would like to allow him to speak, as is his right under Marcy's law. I would also like to point out that, just to be very clear, we are not at 72 hours. Therefore, Your Honor is not required to give this defendant a signature bond. We were very clear about the calculations. We were very clear yesterday with Judge Lowe about the calculations, which she agreed with, which we are not at 72 hours until 11 o'clock tonight, which is why we're going forward today rather than asking the DA's office to make a decision this evening and have the case transferred this evening, it would have been too late, which is why we are having this bond hearing today.
All right, thank you, Deputy Falk. All right, I saw, well, I'm looking back on my screen again.
Mr. Christopher Dunaville, if you're here, can you please turn on your Zoom?
Right, okay. It just says iPad. That's right, I was looking for the name. All right, Mr. Dunaville. Unmute yourself with the little red microphone.
Can you hear me now, Judge?
Now I can, yes.
Okay.
All right, Mr. Dunaville, would you like to address the court today?
Yes, Your Honor.
All right, I'm going to swear you in first. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes.
All right, and you have someone else in the room with you as well?
My wife, but I'll be the only one speaking.
Be the only one speaking? All right,
Yes.
I will briefly let you speak, and I remind you, this is a bond hearing. This is not a trial, but this is just the bond hearing. So let me know what you would like to say to the court today.
Yes, ma'am. As you know, my son has passed away. He was my only son. It is very hard on our family. And the baby, the mother was pregnant with the baby, and she was there on the scene and had to witness all this and render first aid to him and watched him pass away. And my family is devastated, and we don't understand why this person would have to be so malice like this. And my son would go to church. He would go to the 8 o'clock service, but adults don't even go there. And he was bringing kids from the Riverdale High School to Light of Joy. And he didn't deserve this. And we would just like to have justice, Judge. Whatever you can do for us, because we're just distraught about this. We stay in Riverdale too. And we also stay in Riverdale as well, Your Honor. And so we just beg you and ask you, Your Honor, and we appreciate the district attorney and the police department for apprehending him, Father God. But we're just destroyed. We don't know what to do. Our young son was never into anything. He had just moved in the house down the street on Beseda off Old National. He had just got baby clothes and baby stuff. We were supposed to have the baby shower next month. He had moved in the house. He had put everything together, and he was about to marry the girl because he said he didn't believe that men should be having babies around and not married woman. And we're just tore up. We don't know what to do. And I just ask Your Honor for you to just do what you can for us. Thank you.
All right, I am so sorry for your loss. Thank you for your time. All right, anything else, counsel, before I give my ruling?
Nothing further from the state, Your Honor.
Nothing from the defense, Judge.
All right, I'm going to order a surety bond, and that surety bond amount is going to be $150,000. And with that surety bond of $150,000, I'm going to request that, again, the defendant would possess no firearms while on bond, that he would surrender any firearms that he has to the sheriff's department as soon as possible, that he had no drugs, alcohol, or weapons and firearms of any kind while on bond, that he have no contact with the family of the victim, and that would be the Dunaville family. No contact, direct, indirect, or social media the third parties. I'm gonna also order that he have no further contact with the other victim on the scene, and I did not write her name down. Deputy Falk.
Yes, Your Honor. Her last name is Mackenzie, and that is going to be, let me just make sure I am accurate on that. Mckenzie. First name is Carmella, Carmella.
Same thing with Carmella McKenzie. And when I say no contact, I mean no social media, no third parties, no internet, no emails, no phone calls, no contact whatsoever with her, so that there's no intimidation on her part. I'm going to also order a stay away from the Shell station at 7100 Old National Highway. And is there anything else, counsel, that I need to take up at this time?
Nothing from the state, Your Honor.
And let me ask this one last question. As I've stated, no contact with any of the immediate family or relatives of the deceased victim, Trayvon. And I don't know if we need to name any specific names of the parents. I did give Carmella McKenzie, and just making sure with the state there are not any additional names that you would like to specifically put into the bond order.
Your Honor, we would ask no contact with Tabitha Clem, which is the mother, and Christopher Dunaville, which is the father of Trayvon Dunaville.
All right. Do you have that, Mr. Jordan?
Yes, Judge.
Okay. All right, if there's nothing else, then that will conclude this bond hearing.
Thank you, Your Honor.
Thank you.
Next is Ms. Glover.
Kiana Glover. (22 CR). Is that in courtroom 3?
Yes.
Okay. All right. 22 CR 008275G. Kiana Glover, charged with 1 count of battery family violence, offense date December 14th, 2022.
Fifth arrest.
Second.
Last arrest.
I didn't hear you. Second arrest.
Fifth. You heard me?
Yes.
Last arrest was in January for trespass that was dismissed. 2019 DUI dismissed. 2017 probation. Got a disorderly conduct conviction, battery first offender, battery DV from 2015. That's all.
All right. Deputy Falk.
Yes, Your Honor. And that battery family violence and disorderly was sealed as part of first offender in 2018. I'm also seeing I'm not sure if Mr. Howard said this, and I apologize if he already covered it, a 2017 probation violation as well out of Douglas. This incident happened December 14th at 1:30 a.m. at 2423 MLK Drive, apartment 2208. The defendant was in a physical and verbal altercation with Deja Johnson, that is DAJAH, last name common spelling. Miss Johnson had bruising to her cheek, nose, and scratches on her neck. Miss Johnson stated that the defendant was going through her phone, found that she had been cheating and talking to other women. Miss Johnson stated the defendant began punching her, scratching her, and pushing her around the apartment. Miss Glover also had a belt in her hand when the police arrived, which was corresponding to a welt that was found on Miss Johnson's cheek, where it appeared that she had been struck by a belt. Miss Glover admitted to going through Miss Johnson's phone And she claimed it's because she felt that Miss Johnson had been moving funny and went through her phone and found messages. At that point, Miss Glover claimed that they began fighting one another. They have been in a relationship since February, March, have been living together since June, July, which is where the family violence comes from. We did dismiss the charges against Miss Deja Johnson. She was charged as well because we did determine that based on all of the circumstances that Miss Glover appeared to be the predominant aggressor in this case. We are asking for a $4,000 surety bond, no further contact, stay away from Miss Deja Johnson, and stay away from the residence at 2423 MLK Drive, apartment 2208. We're also asking that there be no alcohol, drugs, or weapons. The state did not have an opportunity to speak with Ms. Johnson, understandably, because Ms. Johnson had also been arrested since the officers could not determine a primary aggressor at the scene since they were both blaming each other. But based on the fact that the majority of the injuries were suffered by Miss Deja Johnson, the fact that Miss Glover had a belt when she opened the door to the police, which indicated she was engaged in some sort of activity, and the corresponding injuries to Miss Deja Johnson, as well as Miss Glover's previous history of family violence battery, that is how we made our determination as to the predominant aggressor. And I will say that Miss Deja Johnson, who was the victim in this case, has no history whatsoever.
All right. PD Woodbury.
Yes, Your Honor. So as the state indicated, the police did arrest both women because they could not determine who was the primary aggressor in this situation. And I would also highlight that the state indicated that they have not subsequently followed up with the alleged victim to get any more information about the situation. So I do think it's a bit more complex than the state is making it out to be. Regarding Miss Glover, she is gainfully employed at Planet Fitness in the member services department. She was born in Georgia, lived her whole life in Georgia. All her family is here. She did graduate from Douglas County High School and did some college. Judge, she is not a convicted felon and has no failures to appear, so we know she will come to court. Regarding the address, Ms. Glover tells me that her name is the only name on the lease, so we would be opposed to a stay away from that residence. We would also be asking for no further violent contact, and we would be asking for a signature bond today.
All right. I'm going to order the $4,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with Deja Johnson. I'm going to order stay away from 2423 Martin Luther King Jr. Drive, apartment 2208. I'm going to allow a one-time law enforcement escort for Ms. Glover to get any items or remove any items from personal items from the property. No, I already said no drugs, alcohol, or weapons while on bond. Anything else, counsel, that I need to take up?
Nothing further from the state, Your Honor.
All right, thank you.
How much is the total bond?
$4,000 surety.
Thank you. Next is Ms. Pease.
Say that again.
Ms. Pease, Emily Pease.
All right. This is 22 CR 008280Y. Emily Pease, you're charged with 1 count of battery. The offense date is December the 14th, 2022. Pre-trial. All right. ASG. Oh, I'm sorry. ASG Stockton.
Yes, Your Honor, this incident did occur at the location of 1132 Oglethorpe Avenue. The victim in this case is Martha Pound. Martha Pound is the roommate of the defendant in this case, and it's indicated from the facts in the warrant that there was an altercation where the defendant bit the finger of the victim in this case. However, Your Honor, I want to take a moment to kind of explain what's really happening in this case, because the warrant just says that there was a bite. However, the severity of that bite was not translated into the warrant. This defendant did in fact bite this victim's finger in half to the point where her bone was exposed and she lost a fingernail. The victim indicated to us that the defendant spit that fingernail back at her. She's had to go to the doctor to get her finger sewn back together, and she has been referred to a hand specialist to see if she can would ever be able to grow a nail again and to be able to properly use her finger. The state is going to be proceeding with this case and referring it up as an aggravated battery, given that additional information. We're just trying to gather all the medical records necessary to send it to the DA's office. So the state is going to be requesting that Your Honor give a bond in accordance with the nature of the offense alleged. We do have pictures of the injuries sustained by the victim, and we did make contact with her today. She also has an additional doctor appointment coming up. They are roommates. She wants the defendant to stay away from the residence until she can move out, which will not be until January 27th of next year. She stated to our victim advocate that she may be on the Zoom today, so I would like Your Honor to sound for her at the appropriate time. Given the facts and circumstances, while the state is aware that this defendant does have no criminal history beyond this, given the severity of the offense and the fact that this victim's finger was bit open with bone exposed and a fingernail spit in her face to the point where she has to get her finger reconstructed, we believe a $10,000 surety bond is more than reasonable in this case, that the defendant have no further contact with Martha Pound, that she stay away from their shared residence, and that there be one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, thank you. Ms. PD Kim?
Yes, Your Honor. We would like to, okay, Miss Pease is actually 37 years old, and she was living here in Georgia for about last 10 years. And she is a full-time student at Maury master's program. She's pursuing master's degree for nursing, and she is a single, and her families are here in Georgia, so she has a strong ties to the community, and she's not a flight risk, and this is her first offense. And we would like to request for a signature on bond. Your Honor, indeed, the house that they reside together is basically owned by my client, Miss Emily, and she sent out termination letter because for the verbal lease agreement they had. She's willing to file for eviction if she does not move out until maybe about January 27th that the solicitor was supposed to. So she would like to have a one-time law enforcement officer visit to retrieve her personal belongings at that location. We would like to request for a signature on bond. That's it, Your Honor. Thank you.
All right. I'm going to order the $10,000 signature bond, the pretrial per judge. I'm going to order that there be no further contact with the victim, Martha Pound. I'm going to order a stay away from 1132 Oglethorpe Avenue until after the date of January 27th. And then on January the 28th, the defendant with law enforcement can go back to that location. And if the victim has moved and there are no belongings there of the victim, then she can begin to reside at that location on January the 28th or subsequent to that. No drugs, alcohol, or weapons while on bond. And I think you also requested a one-time law enforcement escort now in order to get some belongings prior to the 28th, which I will grant that.
Thank you.
Did you say anger awareness?
I will now. Thank you.
I mean, I was just asking.
One day anger awareness course. And is there anything else, counsel, that I need to take up?
Nothing further from defense.
Just they would just
Someone
object to
raising
the
their hand.
signature.
I'm
the
so
signature
sorry.
Given the injuries.
I'm sorry.
The state would just object to the signature given the nature of the injuries alleged, nothing further.
All right, thank you. I do see someone with Neely raising their hand. Yeah.
Yes, ma'am. I'm the victim.
Oh, I'm so sorry.
I just,
Hold on
I
one
just-
second. Hold on
okay.
1 second. I would have loved to have heard from you before my ruling, but let me hold for a second because I do obviously want to give the victims an opportunity to speak and be heard by the court as it is your right to do. So let me swear you in and then give me your name. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, state your name again.
Martha Neely Pound.
Okay, all right. What would you like to tell me, Ms. Neely Pound?
I just wanted to reiterate how terrifying this experience has been. I have barely even been at that house for the past few weeks since she began having this episode. She has been abusing amphetamines and has been terrorizing me verbally up until this point. She vandalized my car on Monday, which I have a
Your Honor, objection to its irrelevant facts.
It goes to prior difficulties between the parties, which is relevant to the danger to this particular victim and the other IALA factors.
All right, I will allow some limited testimony about some other events if it was close in time around this
Just
incident.
within the last 72 hours, the vandalism, and I have recordings of her banging on my door after I had gone to bed, screaming profanities and threatening me. And then it followed up with this attack 2 mornings later, unprovoked. I had not spoken to her that morning. She came into my bathroom while I was naked with the door locked. She picked my locked doors and assaulted me. And she's twice my size. She wouldn't let me away from her. And I just wanted to let you know how terrified I am, first of all. And second of all, I just wanted to point out that she has plans to leave on a cruise next week. And I do consider her to be a flight risk, and her impulsiveness and inability to control her impulses leaves me fearful that she won't be able to uphold her staying away.
Well, if she does not uphold the stay away, which again, she is only to come to the location, as I stated, to your apartment with law enforcement. If she shows up there without law enforcement, don't open the door and call the police.
Okay.
She will be arrested for violating the terms of this bond order.
And will she be required to let me know when she's coming as well?
Usually, yes, the police should make sure, but I've heard of cases where depending on their schedules, they're not always able to do that, but hopefully they will contact you to make sure that it is a good time, obviously, so that when they come, they don't waste their time if you're not at home.
Okay.
I've heard some situations where they show up with that person and, you know, you're forced to kind of do that without notice.
Okay.
But try to be as cooperative as you can within reason.
Absolutely.
For her to get some of her items prior to the 28th of January.
Your Honor.
At that time, if you have, now, is it still true that you're going to move out by the 27th?
Yes, ma'am. I'm actively seeking a new place to move.
Okay, great. And then on the 28th, you know, hopefully you will be in another safe location and you won't have to worry about her coming back at that point with you there.
Yes, ma'am.
But it sounds like you are still in fear. And again, that's what 911 is for if there's any subsequent incidents. And hopefully there would not be, but we are concerned and want you to be safe.
Thank you.
All right.
I appreciate that. Thank you, ma'am.
Just one thing to
Yes.
clarify, Your Honor, since the complaining witness mentioned that she has been residing at the location only for a few weeks, which means less than 30 days. If my client files for an eviction, she can get, probably she does not have any requirement to notify her to stay there for like until January 27th. This is her house. If my client gets the writ of possession within 7 days, I think she has my client should be entitled to come back to her house. Can you please let that January 27, 2023 to the date of the court order from the magistrate court if she gets the date, the writ of possession is issued?
And Your Honor, I just want to clarify, sorry to interrupt, PD Kim. I don't think that's the issue. I think what the victim in this case was saying that she hasn't been staying there a lot lately because of the way that this defendant has been acting in terms of verbally and physically attacking her and opening her locked doors. That's what she's saying. She's been there. She just hasn't been able to be there the way she chooses to be because of the defendant's action. So I do believe that the judge's recommendation as far as the stay away in accordance with her ruling is appropriate.
I will say this, and Mr. Jordan, we may add this. I'm going to order in the bond conditions that the defendant not pursue any dispossessory or any landlord-tenant actions against the victim until after the victim has been allowed to vacate, which would be after January the 28th. Because what I don't want the defendant to do is to not disclose to the court that there is a bond order with conditions of her regaining residency only upon law enforcement escort, and maybe not be truthful and get this dispossessory warrant, and then they come to put the victim out prior to the 28th. So I will say that she will not pursue any type of dispossessory, writ of possession, any type of legal actions to have the victim removed from the property prior to January the 28th. All right. Yes.
Just to clarify, I have been living there for 15 months total.
That's fine. But at this point, we again want to make sure that you're safe, since we have allegations of a very violent situation. We want to make sure that you have some safe areas or safe places that you can stay in the interim until you're able to find a new residence. Okay.
Thank you. I appreciate that, Your Honor.
Yeah. All right. That will conclude this
Absolutely, I
meeting.
agree. I understand that and I agree to it.
Ms. Pease, you are not to be speaking. Your
Okay.
attorney is going to tell you that. Please do not speak.
Okay.
All right, thank you. All right, that should conclude this case. Thank you, everyone.
Thank you.
Next is Ms. Stockton.
That's Stockton.
Yes, ma'am.
Okay. Case number 22 CR 008284Y. Adriana Stockton, charged with one count of theft by taking, offense date 11/26/2022, pretrial.
A fifth arrest, 2015 probation conviction, 2016 shoplifting arrest. Got first offender for 2 counts of identity theft fraud. That was from 2012. And a 2012 I hate this charge. Destruction, removal. It's one of those car issues. Basically hiding the car without paying the payments. That's it.
All right. ASG Campbell.
Yes, Your Honor. The facts alleged for this defendant are that on the date of November 26th of this year, at the location of 2615 Donald Lee Hollowell Parkway, which is the Family Dollar, the police were dispatched for a call of an employee stealing electronic and household items from the store. Further investigation did reveal that this defendant, Adriana Stockton, was working at that location. She was seen on surveillance video making scanning motions on several items. However, she did not actually scan the items. She did bag the items and hand them to an unidentified female, her accomplice. Additionally, this defendant was seen on surveillance video taking electronic items from behind the cash register bagging those as well and handing those bags over to the other female accomplice who was unidentified at this time. In total, Family Dollar did suffer a loss of $860 of merchandise, electronic and household goods. And for those reasons, considering the fact that her last conviction was in 2012, and she did receive first offender probation, the state's recommendation for bond is a $3,000 signature bond through pretrial services, a stay away from the incident location of 2615 Donald Lee Hollowell Parkway, as well as anti-theft counseling while she's out on bond. Nothing further from.
Give me again the request of the no further contact, the victim's name.
Oh, Your Honor, I'm not asking for a no further contact, just a stay away from the Family Dollar.
Store. Okay, from the store. Okay.
Yes, Your Honor.
All right. PD Kim?
Yes, Your Honor, we do not have any objection to signature on bond. As long as it is $3,000 signature on bond through jail, that'll be great. And we would like to object to the course that should be only for the people who are convicted. At this point, she's presumed to be innocent. I don't think she should be taking any classes, Your Honor. She has 5 children, 2, 8, 9, 13. She does not have a job. She has not had a job for the last 1 week. Your Honor, we would like to request for a signature bond through jail. Thank you.
All right. All right, I'm going to order a $3,000 signature bond through the jail. I'm going to order that the defendant will stay away from the Family Dollar at 2615 Donnelly Hollowell Parkway. No drugs, alcohol, or weapons while on bond. And I think that is all for the moment. Anything else, counsel?
No, Your Honor, thank you.
Nothing
All right.
further from defense.
All right, that will conclude this case.
Position 1, Albritton.
This is 22 CR 008271A, Edwin Albritton. Your charge of 1 count of battery family violence. Offense date is 11/5/2021. Pre-trial.
26 total. Got a 2020 suspended license conviction. 2019 probation, 2018 failure to appear for theft by taking. 2018 suspended license conviction. 2016 theft by taking conviction. 2015 simple battery family violence arrest. 2012 probation, simple assault. Disorderly conduct conviction, failure to appear, 2012. 2011 simple assault, NOLO. You got more suspended license convictions. Has 1 arrest out of Alabama. That was 2016, obstructing justice, theft by receiving, carrying prohibited, and obscuring ID of vehicle. That's it.
All right. Deputy Falk.
Yes, Your Honor. This incident happened November 5th, 2021 at 3154 Reeves Circle Northwest. Miss Stridden, that is Joaniqua, so Janiqua Stridden, Stridron, stated that she had arrived home and was putting away groceries when the defendant came to her house and parked in front of her house. He called her over to his car, and then exited the vehicle when she came over. According to Ms. Stridden, she told the defendant he was acting like a stalker, which made him upset. She stated she went back to her car, sat in the driver's seat because she was scared, and went to call the police. The defendant walked up and struck her in the forehead with his fist. She then exited the vehicle. He grabbed her by her neck and began strangling her. And he stated, "I will shoot a bitch like you." And when she told him police were coming, he said, "Bitch, you have my information." On-site security guard actually arrived at the location and detained the defendant, but then had to release him because he was detained for over an hour and no officers were available to come to the scene. So by the time the officers got to the scene, the defendant had already left. When they called him, he stated he was in Douglasville. Ms. Stridden had bruises and scratches to her neck and her inner right arm, as well as her head. Again, this defendant has some previous history that is of some concern, including a simple assault out of Clayton in 2011, failure to appear in 2011 and 2012, a probation violation in 2018, a simple battery family violence plea in 2002. In 2015, he had a null prost simple battery for over 65 or pregnant person. And then he had a carrying concealed weapon and deadly weapon at a gathering in 2001, which he pled nolo to. He also has that 2016 case out of Alabama, which does give us some concern for his ties to the community. We are requesting a $5,000 surety bond, stay away from 3154 Reese Circle Northwest, no further contact with Ms. Stridden, and no alcohol, drugs, or weapons. Again, our concern has largely to do with the number of violent offenses in his history, as well as his interaction with Ms. Stridden on this date. Thank you.
All right. PD Woodbury.
Yes, Your Honor. So I would first point out that this incident is alleged to have occurred over a year ago. Mr. Albritton, I did not hear that he was a convicted felon. I did not hear felony history in that recitation. I would say that he maintains his innocence. We would not agree with all the facts recited by the state. Mr. Albritton is gainfully employed. He works for top-notch staffing service. He works in a warehouse. He was born in Georgia. His family is here. His parents are in the state. He attended Booker T. Washington High School, so he does have strong ties to the state. Judge, we would ask for no further violent contact with the alleged victim, given the age of the case. And we would ask for a signature bond today.
And Your Honor, I just want to sound for Ms. Stridden. We were not able to have contact with her. I'm not sure if the public defender's office was able to have contact with her. Just out of curiosity.
We were not.
Okay,
Yes,
so
Ms. Stridden, is it Stridden? No, it's hard to pronounce. Stridden.
yes. Also, being that none of the parties have had contact with her, I would object to a no further violent contact. We would prefer, in an abundance of caution, to have a no further contact based on these facts. And then if Ms. Stridden wishes to have that lifted at a later date, she will have the option to do so.
Okay.
Judge, given the age of the case and the fact that it doesn't sound like there's been any issues alleged since over a year since this happened, we would still be pushing for the no violent contact.
All right. I'm going to order the $5,000 surety bond. I'm going to order no further contact with the victim, Jonique Stridden. I'm going to order a stay away from 3154 Reese Circle and no drugs, alcohol, or weapons while on bond. All right, that should conclude this case.
Thank you, Your Honor.
Position 2, Castillo.
All right. This is 22 CR 008272J. Castillo Munoz, 1 count of reckless stunt driving, 2nd count of obscured or missing license plate. Offense date 10/16/22. Pre-trial.
Appears to be the first, based on my file.
All right, Deputy Falk.
Yes, Your Honor. We did actually have an opportunity to pull the driving history of the defendant, since this is a driving offense. We have a following too closely in April of 2022 out of Gwinnett County. Very pertinent to this case, a racing charge from June of 2019, June 14th, 2019 in Gwinnett County, where he was convicted. A speeding in May of 2017, 64 and a 45 in Roswell. It appears he was also convicted on that offense. And obstructing traffic in March 16th of 2017 in Roswell. The facts on this case is October 16th of this year, officers were dispatched to 2030 Bolton Road Northwest in regards to a suspicious vehicle. The vehicle was a Dodge Challenger with 2 black stripes that they believed to have been involved in street racing. Clarence Farmer, who was a witness at that location and an employee at that 2030 Bolton Road Northwest location, stated that vehicles had taken over the street at the intersection of Bolton Road and James Jackson and were drag racing, and that the Dodge Challenger that was the subject of this was doing spin outs in the middle of Bolton Road and James Jackson intersection before the owner then parked the car at the above location due to a damaged wheel. Mr. Farmer also presented officers with video showing the vehicles, which included the Dodge Challenger, starting approximately 3:45 a.m. and going to about 4:20 a.m. Rutilio Arcos, who was on the scene at the time, was changing the tire on the Dodge Challenger. They spoke to Mr. Arcos. He stated he was called by an individual, Jorge Martinez, who found him online and asked and hired him in order to change the tire. The defendant said he was paid Mr. Arcos stated he was paid $65 to change the tire, and they told him to contact them upon completion. The vehicle information was then later attached back to this defendant, who was then arrested on this offense at a later date. The state's recommendation on this case, and I know Your Honor was at least present for the last 3 days of last week when we had several cases on the calendar. I believe there were over 100 dealing with drag racing, stunt racing, laying drag, just behavior that has been kind of plaguing the city for the last several months, ever since the pandemic. And we are taking these offenses very seriously due to the damage that they create and the havoc they create in the community. We are recommending, based on his history with the prior racing conviction, a $1,500 surety bond for stunt driving and a $500 surety bond for the obscured license plate, for a total of a $2,000 surety bond. We are also further requesting the defendant engage in no driving except for to work, home, school, or court. Nothing further.
All right. PD Woodbury.
Yes, Your Honor. We are asking for a signature bond today, given Mr. Castillo Munoz's lack of history. Judge, he does work as a compounder at the Aralescence warehouse. He lives in Roswell with his aunt. He's from Roswell, attended Roswell High School, has been in Georgia all his life, has strong ties to the community, has never missed court. Judge, I will point out this incident is alleged to have occurred in October. The warrant wasn't taken until December 9th. And Mr. Castillo was contacted by law enforcement. They asked him to turn himself in, and that's exactly what he did. So he willingly turned himself in. I think there's nothing else that could show that he is going to follow directions and appear in court. So we would ask for a signature bond.
I'm going to order the $2,000 surety bond, $1,500 on the first charge, and $500 on the second, for a total of $2,000 surety bond. I'm going to order that the defendant would only have limited driving privileges, and that those limited privileges would be driving to work, to court, or for medical care. Other than that, the defendant should be at home. I'm going to also order no drugs, alcohol, or weapons while on bond. Anything else, counsel?
Nothing further from the state.
All right.
No, Your Honor.
Position 5, Henderson.
is Travis Henderson, 22 CR 008276F. You're charged at 1 count of simple battery family violence. The offense date is October the 12th, 2022. Pre-trial.
36 total. Last arrest was in May for battery DV out of Fairburn. 2019 misdemeanor possession of marijuana. Basic rules conviction from 2015. 2014 probation for a suspended license. 2013 suspended license, it was NOD. 2013 cruelty in the first and battery. It just says transferred to Superior Court. He got more suspended license convictions in the system, dating back to 2011. 08 probation for possession of cocaine. He had a burglary and aggravated stalking arrest from 08. It was not presented to a grand jury.
All right. Deputy Falk.
Your Honor, just to fill in a little bit, that 2015 cruelty, he ended up taking he ended up being convicted for cruelty in the second degree. The victim in that was Shavante Wynn, who was a child. He received 3 years probation as a result of that here in Fulton County. He did have a probation violation subsequent in 2014, and he does have that 2022 22 CR 003301 case from May 23rd of 2022 involving Trayona Henderson, who is a child of the defendant, where he received a $2,500 surety bond on that case. As well as that simple battery conviction in 2006 out of DeKalb. So just focusing only on his violent history involving other individuals. This incident happened October 12th, 2022 at 8215 Autumn Green Drive in South Fulton. Miss Chewana Henderson, that is CHEOWANA, stated that her and her husband had not been getting along. He was sleeping in a separate part of the house. He came into the bedroom, and she stated she would go sleep downstairs. That point, the defendant held her onto the bed and began hitting her in the head. They are married, have a child, and do reside together. The victim and the defendant do have a domestic violence history. She did state to our victim advocate that the defendant has been accusing her of infidelity and came in and hit the headboard very hard. Their daughter came into the room to see what was going on, and the Miss Henderson stated the defendant then got in her face and hit her on top of the head. She stated she did not sustain any injuries, and she did pepper spray him in self-defense, it appears. She has stated since the incident, she and the family have been going to therapy and that she is not afraid of the defendant. He can come back home. However, I have some serious concerns based on this history. So we have that 2015 cruelty to a child in the second degree. We then have a 2022 case, which just happened 5 months before this case, where he was given a $2,500 surety bond for striking his child, Trayona Henderson, and now has this case with the court. Based on that, the state is requesting a $5,000 surety bond that he stay away from that address at 8215 Autumn Green Drive, no alcohol, drugs, or weapons, and no further contact. I don't know if Mrs. Henderson is here, but we would like to sound for her.
All right, Mrs. Henderson.
Yes, ma'am, I'm here.
Okay, can you turn on your camera for me?
Yes, ma'am. Give me 1 second. Yes, ma'am, I'm here.
All right, would you like to address the court regarding this case?
I would. Me and my husband right now.
Hold on one second. Need to swear you in. Raise your right hand for me.
Okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. And now you can tell me what you want to tell me.
Yes, ma'am. I was saying, since the incident, me and my husband and my children, we have been seeking counsel. Like I stated to the advocate, I have no fear of Mr. Henderson. We have a grandchild on the way any day now. So doing no contact will not, it will not help bond our family together like we're working on doing. That's all I have to say. I'm just looking forward to him coming home so we can continue to work towards building our foundation.
All right, any cross-examination, Deputy Falk?
Ms. Henderson, just very briefly, so you are in fact acknowledging that he did strike you on this evening?
He did. He hit me on top of my head, and when he did so, I pepper sprayed him at that time. Yes,
And
ma'am.
and that he has in fact also physically harmed your daughter, Trayana Henderson.
And with my daughter, he did not hear her that day at the store. She did explain to the courts where it happened, so I wasn't there for that instance. But like she stated, that it didn't go on.
Okay. That's all from the state, Your Honor, nothing further. And oh, I'm sorry, Ms. Henderson, you also do acknowledge that you called the police as a result of this incident?
I did.
Okay, nothing further for the state, Your Honor.
All right, PD Woodbury?
Yes, Your Honor. So Ms. Henderson appeared today to tell the court that she is not in fear of Mr. Henderson, that she wants him home and wants contact. And I would ask the court to honor that. She has been waiting on the Zoom now for over an hour to tell the court that. Judge, Mr. Henderson, he is married to Ms. Henderson. They do have 3 children together. He has been in Georgia all his life. He is self-employed, doing carpentry work, and he does support the family. I would ask that he be allowed to return to the residence. He tells me that both his and his wife's names are on that lease. And I would ask that he be allowed to have contact with her. As Ms. Henderson said, it sounds like they're going through counseling and getting and doing that. So that's what we would ask, and we'd ask for a signature bond.
All right. I'm going to order a $5,000 surety bond. I'm going to order no further violent contact with Mrs. Henderson. And I won't order stay away, but that no further violent contact, no drugs, alcohol, or weapons while on bond. And is there anything else you want me to take up, counsel?
No,
Nothing
thank you,
further,
Judge.
Your Honor. Thank you.
All right, thank you.
Said 5,000?
5,000, yeah.
Position 6, Lowe.
Marvin Jamal Lowe, case number 22 CR 008273J. The charge is 1 count willful obstruction of a law enforcement officer. The offense date is 12/14/2022. Pretrial.
Got 19 total. He had a 2017 arrest out of Ohio, domestic violence, robbery. Disorderly conduct, it was reduced to disorderly conduct. The disorderly conduct was a conviction. Last arrest in Georgia was 2021. Probation for suspended license, possession of marijuana, possession of drug-related objects. Also was arrested in DeKalb County, 2021. Cruelty in the third, battery DV. 2021 suspended license. 2019 suspended license. 2017 probation. I got a forgery and theft by receiving. 2012 another probation, theft by taking from 2011. 2011 simple assault conviction. That was out of DeKalb County. First offender for theft by receiving, 2011. 2011 probation. 2011 out of DeKalb. Got battery DV, disorderly conduct. Those were convictions. Simple battery, family violence, reckless conduct conviction out of 2011, Rockdale County. 2011, more probation violations, and that is all.
All right. ASG Duncan?
Yes, Your Honor, this incident did occur yesterday on December 14th, 2022 in the area of 230 Cleveland Avenue. Officers stopped the defendant who was driving a vehicle for a traffic stop. However, when they made the traffic stop for this defendant, and they gave him verbal commands to get out of the vehicle, he refused to do so. He continued to sit in the car, smoke a cigarette. Officers told him to get out of the vehicle. He said, wait 1 minute. And when Officer Gover went to open the door to get him out of the vehicle, he slammed the vehicle door back. At that point, Officer Grover did call for backup. His backup officer was able to talk the defendant out of the car. It was indicated that he was possibly wanted out of Gwinnett. However, that was not confirmed. However, the defendant was operating this vehicle, according to officers, with a suspended license. Given the fact that he did not respond to these officers' commands and in fact obstructed their investigation and commands, we're concerned here about the risk of reoffense, given that this defendant does have at least 18 cycles in Georgia, is a multi-state offender, and has several convictions with probation revocations in tow. So we do have concern about the fact that this defendant is likely not going to respond positive to the legal process. There is a $2,000 surety preset on this case, Your Honor. However, the state is amenable to reducing that bond to $1,000 surety, and that this defendant have no further violent or obstructive contact with the officers named in this offense, have no alcohol, drugs, or weapons, and no further violations of Georgia law. Nothing further from the state.
All right. PD Woodbury?
Yes, Your Honor. So Mr. Lowe, he resides in Decatur. He works in the Kroger warehouse. He has been in Georgia for the last 20 years, attended Cedar Grove High School, and has 2 children here in Georgia with him, ages 10 and 7. So he does have strong ties to the community. I did not hear any failures to appear on that recitation of his criminal history. Judge, regarding the case and the little I know about it at this point, you know, as the state indicated, there was the police seemed to believe that he was wanted out of Gwinnett, that Mr. Lowe was wanted out of Gwinnett, and that turned out to be incorrect. So I don't know how much of the stop was based on that, but that certainly is a factor in this case. We would be in agreement with the state's reduction to a $1,000 bond, although Mr. Lowe would certainly prefer a signature bond.
And Your Honor, if I may add to the record, my apologies, I omitted this in my recitation. Once the defendant was taken into the custody of the officers, he continued to spit in the back of the patrol vehicle, and he was spitting through the gates, and some of that spit did in fact get to the front of the vehicle. So not only did he obstruct during the traffic stop for the possible warrant, he continued to after he was taken into custody and handcuffed. Nothing further.
Okay. I will agree to the decrease to the $1,000 surety bond. And no drugs, alcohol, or weapons while on bond. And I guess that's all. Counsel, anything else that I need to take up or add to the order?
No, Your Honor, thank you.
All right, thank you.
Position 7, Manson.
All right, this is Horace Manson, 22 CR 008277H. You charge it one. All right, someone needs to mute themselves. All right. Charge of 1 count of battery and a 2nd count of battery against a female who is pregnant, both with the offense date of 11/19/2022. Pre-trial.
28 total. You got open case out of state court. Seatbelt violation, DUI, no proof of insurance. On probation, 18 SC 157540. Possession of a firearm by convicted felon is the charge. One moment, Judge. All right, so 2021 probation, possession of a firearm by convicted felon, misdemeanor possession of marijuana. Got a 2021 entering auto that was dismissed. 2018 probation. 2016 probation, underlying charge of robbery that came off of a 09 SC 78258 case. I got 2012. He was charged with some capital offenses. Those were non-process, if I'm not mistaken. 2012 probation for simple assault. 2011 simple assault conviction. 2010 a freight conviction. 2010 he was charged with riot and battery. 2010 battery conviction out of Hall County. Yeah, 2009. I got ag assault, possession of a knife or a firearm during the commission, possession of a firearm by convicted felon, robbery. Those were convictions. 2009 simple battery conviction. I think that's it as far as all the violent charges, as far as convictions.
All right.
This is my case, Your Honor. This offense did occur on November 19th, 2022 at 2000 Sullivan Road, which I believe is the Amoco gas station. In this offense, Your Honor, the victims are Charlie Daniels, that's CHARLIE, last name DANIELS, and the other victim is Jakia Munford, that's JAK''IYA, last name MONFORT. In this incident, Your Honor, the both victims were at this gas station, and victim Munford sent her boyfriend, victim Daniels, back home to the store to get her purse. While he was gone, she stated to officers that she was approached by the defendant in his case. He made advances towards her, and when she rejected his advances, apparently he became angry. And then a verbal altercation ensued because he called her a bitch and a hoe. And during that verbal altercation, he did punch her in her face. At this time, her boyfriend had returned to the store. Miss Mumford indicated that the defendant in this case was about to try and pick her up. She stated to him that she was pregnant, and he said, I don't give a fuck if that bitch is pregnant. And then he punched her in her face. And she stated to officers that she kind of blacked out a little bit from being struck by the defendant. When her boyfriend, the other victim in this case, attempted to intercede in the altercation between his pregnant girlfriend and the defendant, he was also struck by the defendant in this case, and he received visible injuries. Mr. Daniels received a severe swelling and a laceration above his left eye. He also had swelling to his nose, according to the police report. He indicated to officers at the time that he did, in fact, at that time, believe his nose was broken. The other victim in this case, Miss Mumford, she received swelling and lacerations. This attack continued once they left the store, Your Honor, when they attempted to leave and they got into the brothers. Well, when Mr. Daniels attempted to leave because the pregnant victim in this case ran away, there's video surveillance of the defendant continuing the attack by chasing the vehicle that Mr. Daniels was in and hitting it with a large stick. Officers were able to view that video. Given the violent nature of this offense and the fact that one of these defendants is in fact pregnant, Your Honor, we have some concern about the risk of reoffense and the particular danger to these individual victims, given that they stated these conditions to the defendant and he continued to attack because she did not want to return his romantic advances. We did talk about victims in this case, Your Honor, and victim Mumford did state that they live in a vicinity of each other. And when she sees him around the neighborhood, he continues to suggest threats like, I have something for you. So she is fearful and she does not want contact with his defendant. Given his history, Your Honor, of violent convictions, including aggravated assault, battery, and affray, as well as simple assault and several probation violations, we do think he is a danger to the community. There is a $20,000 preset surety bond in this case That is 10,000 per charge in this case, Your Honor. The state is amenable to reducing that to a $10,000 total surety bond, and that's $5,000 per charge in this case. We'd ask that he stay away from both victims. We'd ask that he stay away from the incident location, which is at Amoco gas station. We'd also ask that this defendant attend and complete a 2-week anger management course and have no alcohol, drugs, weapons, or no further violations of Georgia law. I believe that the victim is on the line, so when the time is appropriate, I would ask that Your Honor would sound.
All right. PD Woodbury.
Yes, Your Honor. Mr. Manson, he is gainfully employed at Furniture Hours. He unloads trucks for them. He lives with his grandmother. He has been in Georgia his whole life. His ties are to this state. He is not a flight risk. Your Honor, there is a presumption of innocence at this stage in the game. We do not agree with the state's recitation of the facts. We are definitely amenable to a bond reduction because Mr. Manson cannot post the bond as it stands right now. However, we would ask the court to decrease it further to $2,000.
And we would just say that we think that $2,000 is not appropriate in this scenario, given that this defendant is a convicted felon and does have prior aggravated violent convictions in his history, and given the facts alleged and the victim's contentions, we do have those concerns, and we think our recommendation is more than reasonable. And again, the victim, Ms. Mumford, is on the line, and we'd ask that Your Honor sound for her. And I believe that she's actually 17 years old as well, Your Honor.
Okay, Ms. Mumford.
Good afternoon, Your Honor. I am the maternal grandmother of Jakaya. She gave me permission to speak for her, if I may.
Okay.
She didn't want to speak, if it's okay with you.
Okay, and I understand she's 17 and you are over 18?
Yes, ma'am.
Okay, and so let me swear you in first. Raise your right hand. Do you affirm that the testimony that you're going to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, and your name is Charlene Munford?
Yes, ma'am. Charlene Catrice Mumford. Yes, ma'am.
And your granddaughter is Jakia Munford?
That's correct, Your Honor.
Okay, all right, what do you know? And I'm going to be a little limited with you because you are not the victim.
My granddaughter went to the store that particular day, and the solicitor did kind of outline most of everything that occurred in the incident.
Okay.
But the fact after the incident happened, the young man was still harassing my granddaughter every time she went to the store.
Judge,
my granddaughter
I'm
has
gonna
a
object
right
to
to walk
this.
the
This
street.
witness was not present.
Ma'am, excuse me.
Ms. Mumford, it's
speaking.
okay. I'll clarify.
I was
Your
sworn
Honor.
on the oath, ma'am.
Ms.
Hold on.
Mumford,
I know
I'll
you are,
clarify.
but Ms. Mumford, let me inform you. You're speaking and stating comments or statements that someone else told you, your granddaughter?
No,
And
Your
I
Honor,
know
may
that
I
she is
clarify? She
17.
was in fact on scene. My apologies, I admitted that. The police report does indicate that she was on scene. So Ms. Mumford, Charlene Mumford was on scene, so she does have firsthand account to be able to speak about what occurred in these events.
And I only want you to speak about what you know about and not so
Yes,
much about
ma'am.
what your granddaughter
This is
told
my
you.
granddaughter. This
I
is something
understand,
my
but
granddaughter.
not what your granddaughter told you. Tell me what you know personally or what you witnessed at the scene that day.
Well, basically, I just want to say that, you know, she have a right to walk the streets, and she shouldn't be afraid of just going to the store across the street from where we live. A lot of this could have been prevented if he had not put his hands on her, but due to the fact that he decided that he wanted to put his hands on a young female at that, that's just unacceptable. And that's, you know, we just can't tolerate that. And that's why we pursued a warrant for his arrest.
Okay. And so I guess as far as knowing that your granddaughter, you stated, is in fear of going to the store because of Mr. Manson, that's correct?
Yes, ma'am.
Okay, okay. And that's what I need to know. All right, thank you for your time and getting on to the Zoom port today.
Thank you, Your Honor.
All right.
And Your Honor, if I may, she did indicate to our advocate, the granddaughter did indicate to our advocate that he has continued to harass her after the incident alleged in the warrant. So we just like to add that, nothing further.
All right, thank you. Yes, PD Woodbury.
Nothing further, Judge.
Okay.
May I say something?
Who is that? Oh, no.
Mr. Manson, I'm going to advise you to exercise your right to remain silent. This is not your trial.
All right, I will go ahead and give my ruling. Give me the incident location. It was 2000.
2001 Sullivan Road, that's SYLVAN Road. It's an, I believe, Amoco gas station.
All right, I'm going to and again, the second charge, battery against the female who's pregnant.
Yes, Your Honor, there are two charges: battery for the attack on the boyfriend when he tried to defend his pregnant girlfriend, and then there's a second charge of battery against the female who's pregnant for the attack on Miss Mumford. So he attacked both parties because Miss Mumford did not accept his romantic advances.
Right. I was just making sure of those two charges. I am going to order the $20,000 surety bond, and that will be $10,000 on each charge. I'm going to order a stay away, and again, I will defer to the state from the Amico at 2001 Sylvan Road, but I was almost going to go a step further to the home or location of the victim because it sounds like it's right across the street from the Amico per the grandmother's testimony. So I want to make sure that he's going to stay away from the Amico and also obviously no further contact with the victims, Charlie Daniels and Jakia Munford. And I'm going to say in any and all family and relatives of Jakia Munford, which would include her grandmother, and if there are any other relatives in that home across the street from the Amico. And I guess where I'm going with that, I would almost include Charlene Mumford as well as Jakia Mumford. And I see grandmother has gotten back on. Let me ask this, Miss Mumford, you all live right across the street from the Amico?
Yes, Your Honor, and it's the Chevron service station.
Oh, it's a Chevron, not an Amico?
Yes, ma'am.
Okay,
Chevron, yes.
Okay, it's a Chevron.
I'm sorry, but it's Amico.
Oh, it is. I'm sorry, Your Honor. It changed the name. I'm sorry. It's Amico, she said.
All right, we'll go back to the Amico. I understand they do change sometimes.
I'm sorry. I apologize.
How close do you live to the Amico?
Directly across the street. You can throw a rock and it's just that close.
Let me also add to make sure that if the defendant gets out on bond, that he also stays away from the address or the location of the victim, Miss Mumford. And do we have that address?
No, I do not have that address. I just had the address of the incident location. If Your Honor could give me one moment, I could check the report to see if it's there.
Okay. Or Miss Mumford, can you give me your address, please?
Yes, ma'am. 2001 Sylvan, SYLVAN, Sylvan Road, apartment 2, dash letter A, Atlanta, Georgia, 30310.
Then what's the address for the Amico? Because I thought that was 2001 Sylvan Road.
That may be like in the 1900, right? It's right across the street. Let me see if I can.
Right. It sounds like we may not. That 2001 is not the.
I'm sorry, it's 1974 for the gas station.
Okay, there we go.
Mm-hmm.
Sorry, Mr. Jordan.
And excuse me, Your Honor, for interrupting you.
Yes.
I understand he has his car is still parked at the service station. Will he need a police escort for him if he does in fact post bond? Will he have to be Can we ask that he be escorted by the police to get his car?
Let me think about that for a moment. He is to stay away from there, and he has to stay away from you. Well, he would,
That's where he was arrested at the service
right,
station.
and his
from my
car is
understanding.
still there.
Yes.
Let's say that he should, because I certainly, I guess, again, you're gonna tell your granddaughter to have some, limited opportunities of going over there. Obviously, she's feeling.
Yes.
So
Yes.
she won't be there. He's to have no further contact with her. But I will order that for him to have police escort to come get his vehicle, to make
Thank
sure
you.
there is no contact or intimidation with
Thank you.
the victim or witnesses.
Thank you so much.
Right. He used to have no drugs, alcohol, or weapons while on bond. And let me say this, and this will be in the bond order. He's to have no contact whatsoever with this victim or Charlie Daniels, by internet, by email, by third parties, other people, by social media, not to discuss her or talk about her, or have other parties to do that. So it goes a little further than just not having any contact with her, okay? Want to make sure that she's safe.
Thank you.
All right. Anything else, counsel, that I need to take up?
Nothing further from the state.
All right, thank you.
Judge, Mr. Manson is raising his hand, so I don't know if he needs clarification.
Mr. Manson, you need to tread light and be careful. Do you have a question about the bond conditions?
Yes, ma'am. Yes, ma'am. So
What's your question?
out of the 20,000 bond you gave me, I gotta pay 2,000.
I just gave you that.
I can't give you that advice. Your attorney will tell you, but if you go through a bonding company, generally 10 to 15%, give or take, it just depends. But that's something you can discuss with your attorney or with the bonding company. They will tell you what is required for a bond.
One more question. You know when my next court date?
I'm sorry?
You know when my next court date?
Oh, if you don't bond out, your next court date will be December 29th.
All right.
Okay. All right. Thank you.
Position 9, Maury.
This is going to be 22 CR 008278, and that is it Vitaly Maury?
Yes, ma'am.
All right, you're charged with 1 count of DUI, less safe, and a 2nd count of failure to obey signs or controlled devices. The offense date is 12/14/2022. Pre-trial?
His third arrest. Well, this year. He was arrested in February and June for DUI. You want the case numbers?
No, I'm fine.
All right, that's it.
Okay. All right, ASG Duncan?
Yes, Your Honor, those DUI cases are open. His entire criminal history does in fact consist of DUI cases. So for the state's purposes of a complete record, we like to add those case numbers. The first one is 22 CR 004098H. That one was a DUI, improper or erratic lane change, improper turn, driving on the wrong side of the road. The defendant did receive a $4,500 good bond from Judge Morrow on June 27, 2022. And then there is another open case. It's 22 CR 007322H. That is DUI, reckless driving, and failure to maintain lane. 2 counts, and that bond did receive a $3,000 cash bond from the Superior Court at that time. In this case, Your Honor, we're going to be recommending a $10,000 surety bond, $9,000 for the DUI and $1,000 for the failure to obey traffic control device or sign. In this incident, it did occur yesterday. Officer Bacon responded to a single vehicle collision call in the area near Barnwell Road in Johns Creek. When he approached the scene, he saw that there was a vehicle stuck in the construction zone near that area. when he spoke to the driver of the vehicle, it was the accused in this case. He told the officer that he did not realize that the road was closed. However, the officer indicated that that road was grimy and muddy at that time. The officer did state that the officer observed that there was large orange road construction barrels placed in the middle of the roadway, and there was a sign erected that read roadway closed. While talking to the accused in this case, officers did notice physical manifestations of alcohol impairment, like bloodshot, watery eyes, and an odor of alcoholic beverage on this defendant's breath. Officers also indicated that he appeared to be unsteady on his feet and disoriented. The officer did ask the defendant in this case to perform a standard field sobriety test of the HGN. This officer has been trained to conduct that sort of test. He conducted the HGN and concluded that the defendant did show signs of impairment in this case. That, along with the other physical signs of and manifestations of impairment and the disregard for those cones and the large sign that was placed before the construction zone, the officer believed that this defendant was under the influence. In addition to the criminal record being totally DUIs that are open, this defendant does have some driver's history, including a citation for failure to appear. So that not only gives us some concern about risk of reoffense, but a flight risk as well, Your Honor. This defendant has an additional suspension for failing to appear and a citation for speeding. So we do have some concern that this defendant is a danger to the other motorists in the Fulton County jurisdiction. And being that this is his third open DUI this year, the state has an extreme concern. And we think that at this time that bond would be more than reasonable. In addition to that, we'd ask that this defendant have no alcohol, drugs, or weapons, no further violations of Georgia law and ADET, and no driving.
All right. PD Kim?
Yes, Your Honor. Mr. Maury is, I am trying to get my notes up. He was born in 1983, and actually he moved from Ukraine. There's a country called the Republic of Moldova, a very small country between Romania and Ukraine. He came from that country on 2018. So he's been here in Georgia for about 4 years. He has 2 children, 11 and 17, and his wife is here as well. He's gainfully employed as an engineer. He's been an engineer for about 12 years. He has a master's degree from Europe, and he graduated from 2 different universities. He also served in the army for about 4 years in Europe. And Your Honor, he is here as an asylum, and he says that his financial situation has been extremely challenging lately because his hours as an engineer has been significantly reduced. So we would like to request for very, very low bond of maximum $1,000. And we oppose to that class ADHD because at this point he's presumed to be innocent. He claims that he was not actually driving at the time. The car was not running. The engine was indeed completely stopped. He was there. It's like a really, really close from his renting condo that he resides with his family. That's what he claims. We would like to request for $1,000 maximum good bond. Thank you.
And I just want to clarify, Your Honor, that this DUI alleged did result in a single car crash. Therefore, before the officers arrived, the defendant had to have been driving at some point to crash through this construction zone. Given that this defendant is out on 2 previous bonds, one of which is a cash, we do believe that the state's recommendation of a $10,000 surety is more than reasonable.
No, I don't think you should talk, Mr. Maury. Your attorney will tell you not to.
Please do not speak, Mr. Maury. This is a bond hearing. You will have a chance to argue for the trial, and you have a right to remain silent. Thank you.
All right, I'm going to order the $10,000 surety bond. That will be $9,000 on the DUI, $1,000 on the failure to obey the signs. I do agree it's disturbing to hear someone was arrested for DUI in February and June, and then again in December. I normally don't order the ADET this soon in the case, but I am very concerned that he gets some help regarding this. So I'm going to order the ADET, alcohol, drug evaluation and treatment, and then you follow whatever treatment is recommended. And I do agree that there will be no driving except to see his attorney and for medical treatment. If he needs to, I guess probably shouldn't drive at all. But I will allow those two exceptions to if he needs to drive, just the two. If he has to go to work, he needs to get a ride, do ride shares, bus or something, or a cab. But the only two instances I will allow at this point for driving are for medical and for legal assistance or meeting with his attorney. I really don't want him to drive at all. It seems like he's not worthy of that. I will make those two exceptions. No drugs, alcohol, no weapons while on bond. And I guess that's it for now.
Your Honor, may I please have a clarification about that? No driving unless for legal purpose. You mean attorney and court, right? I just wanted to.
Yes, I guess it would be court and attorney.
Thank you.
Oh, he'll probably have an ALS and he won't have a license anyway. Let me retract on that. And just no driving unless he has a valid driver's license from DDS, which he probably won't. So that would mean that he can't even drive to come see his attorney or to come to court. Someone will have to bring him. And I think that'll be the safest way. Just don't want anyone to be killed at this point. So let me go back and change that to no driving at all. Unless he has a valid driver's license, which I'm 90% sure he will not.
Mayor, can I have a
Please.
question, please?
Please stay silent. I'll give you a call so you can ask me questions.
Okay,
Thank you.
All right, thank you.
thank you.
Position 11, Pittman.
This is Patrick Pittman, 22 CR 008281C. Charged with one count of simple battery. The offense date is March the 3rd, 2022. Pre-trial.
23 total. Last arrest was 2021. FTAs. Driving without a valid license. Possession of cocaine. Came off of a 2020 arrest. 2018 giving false name, identity theft, fraud, arrest. Suspended license, misdemeanor possession of marijuana conviction, 2018. 2017 failure to appear, it was NOD. 2016 probation, criminal damage to property, possession of cocaine, criminal attempt to commit burglary. Also had FTAs with that arrest. The probation disposition was not prosecuted. 2015 FTA for robbery, came off of a 14 SC 127171 case. 2014 misdemeanor possession of marijuana, probation for theft by receiving, and felony theft by taking. 2012 criminal damage to property, second degree, possession of cocaine, arrest. He had a carrying a weapon without a valid license, conviction from 2004. It was an ag assault with that arrest, but it says dead on it. That's it.
All right, Deputy Falk.
Yes, Your Honor. This incident happened March 3rd, 2022 at 1059 Oglethorpe Avenue Southwest, apartment 203. Miss Tamika Tamika, Alcantara, Alcantra, was staying with the victim under an agreement that the defendant was staying with Miss Alcantara under agreement that the defendant would pay her. Apparently, the defendant and Miss Alcantara lived together in the same foster home as children. When the defendant did not pay, Miss Alcantara asked him to leave. He got upset, grabbed her by the shirt, and pushed her up against a wall. A third-party witness did corroborate Miss Alcantara's account of these events. The state's recommendation in this case, given his history, the number of probation violations, and FTAs, we do have a concern with him not following the directions of court or appearing for court when called, is a $3,000 surety bond, no further contact with Miss Alcantara, stay away from the address at 1059 Oglethorpe Avenue Southwest, apartment 203, and 1 day anger awareness. We would like to sound for Miss Alcantara to see if she is present. Thank you.
All right.
Oh, he on probation for robbery too, Judge. I'm sorry.
No, thank you. All right, Ms. Alcantara? No. All right.
Thank you, Your Honor.
Thank you. PD Kim?
Yes, Mr. Pittman is 39 years old and he was born and raised here in Georgia. He has two children. One is 20 years old, but the other one is only 1 year old. Your Honor, he does not have any objection to stay away from that location, incident location, and also no further contact, even though this happened a very long time ago, remotely, and which is remote. However, he has no objection to no further contact at all. Your Honor, he has not been able to have any stable job for the last 2 years, and he has a GED, and his financial situation at this point is very, very not good. That means even $1,000 good bond is like no bond to him, Your Honor. So we would like to request for signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, even though this happened about 9 months ago, we would like to request that maximum $1,000 good bond. Thank you.
All right. I'm going to order a $3,000 surety bond. I'm going to order a stay away from 1059 Oglethorpe Avenue Southwest, apartment. And I wrote down 2, and I think there was some more.
203.
203. Thank you.
Yes.
No further contact with Miss Alcantara. And no drugs, alcohol, or weapons while on bond. That will be it for this case.
Thanks, Your Honor.
Thank you, Your Honor.
Position 8, McDuffie. Yeah.
And this is a plea, Your Honor.
Your Honor, I recommended, I advised my client, Mr. McDuffie, not to take the plea deal, and yet he would like to take the plea deal, and he understands that he withdraws his my representation as a public defender. Thank you.
All right. Mr. McDuffie. This is case number 22 CR 00827-8D as in dog. You're charged with 1 count of criminal trespass, a 2nd count of willful obstruction of a law enforcement officer. The offense date is 12/14/2022. And I understand that you wish to represent yourself in this matter.
Yes, ma'am.
All right, you understand there's consequences of that, and you're denied about all the laws and rules of evidence if you're going to represent yourself. You understand?
Yes, ma'am.
And I understand that you have completed the plea paperwork. Is that correct?
Yes, ma'am.
All right, and you're representing yourself, correct?
Ma'am.
All right, so I will ask the state to let me know what the plea offer is first, and then I'll come back to you. All right, ASG Duncan?
Yes, Your Honor. The state's recommendation in this case is 12 months probation, 1 day in jail, credit for time served with the balance suspended, and a stay away from the Chevron gas station located at 501 North Central Avenue in Hateville. The factual basis for this recommendation, Your Honor, is that defendant was seen at the location which he had been previously criminally trespassed from the prior night. When officers arrived, he was standing in the refrigerator section of the store. When officers asked him to leave after being informed by the store management that the defendant had a criminal trespass, he became argumentative and he refused to leave the store at that time. When officers attempted to assist him in leaving the store, he became argumentative and began pulling away from officers and refusing to put his hands behind his back. Officers initially had to call for backup, and the defendant had to be rolled in order to be placed into custody in handcuffs, Your Honor. Given that, that's the reason for the state's recommendation in this case.
All right, and so that recommendation again is 12 months probation, credit for time served of 1 day.
Yes, with the balance suspended and a stay away from that gas station at the 501 North Central Avenue in Hateville.
All right. Is it suspended or probated?
Suspended.
Suspended, okay. All right, Mr. McDuffie, is that your understanding of the plea offer from the state?
Yes, ma'am.
All right, and again, you still wish to take that plea unrepresented?
Yes, ma'am.
All right, let me ask you a series of questions to make sure that you understand what you're doing and that it is freely and voluntarily entered by you. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and I'm going to ask you to stipulate to the venue, identity, and the factual basis of the state in bringing this case against you. You stipulate or agree to that?
Yes, ma'am.
Okay. And let me ask you this. At the present time, are you under the influence of any medication, drugs, or alcohol?
No, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're waiving or giving up your right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're waiving or giving up your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, so as to the charges of criminal trespass and willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, so that's 12 months probation to serve 1 day, credit for that time served with that 1 day, and the balance of the probation will be suspended. And the condition is that you will stay away from the Chevron at 501 North Central Avenue in Hayville. Can you do that?
Yes, ma'am.
Okay, as long as you stay away, you won't be rearrested.
Okay.
All right, so I will accept your guilty plea and then they will process you for release, okay?
Okay.
All right, good luck to you.
Thank you, ma'am.
All right, you're welcome.
Good morning, Your Honor. My name is Darius Reese. Good afternoon.
I'm sorry?
Good afternoon. My name is Darius Reese.
All right, the deputy didn't announce you, but I guess
Oh,
you're,
I'm sorry, Judge. This is position 13 and 14, Reese.
okay, no worries. We have position 22 CR 008283F, Darius Reese, you're charged of 1 count of criminal trespass.
Ma'am, yes, ma'am.
All right,
You ready?
yes, sir. Pre-trial, yes.
12 total. Last arrest was in May, probation violation. Criminal trespass. Trespass was a conviction. So he's on probation in Clayton County, criminal trespass. Criminal damage to property, second degree, aggravated assault. April 2022, he was arrested for the battery in Clayton County. 2021, hit and run, Lowe. 2021, those are the convictions that he's on probation for. 2019, probation violation, burglary in the first. 2018, probation burglary. Another 2018, probation burglary. 2018, trespass, misdemeanor possession of marijuana. Trespass was no low. The marijuana was dismissed. And 2017 was the burglary. 2016, simple battery. That's it.
Okay. Deputy Falk?
Your Honor, I just want to clarify, although there are two cases that are showing on the calendar, he's only charged with the one count of criminal trespass in this case. I just think it was a duplicate. What occurred in this offense is that on December 14th, 2022, the defendant was at 2848 East Main Street in East Point. He was at the East Point MARTA station. MARTA had a suspension on him that was in place until January 24th of 2023. And on December 24th of 2022, the defendant was, on this date, December 14th, the defendant was observed on the property drinking from a bottle of Bacardi, and then they made an arrest. As pretrial has already stated, he has a number of active offenses, 2022 hit and run, 2022 aggravated assault, 2022 trespass, all out of Clayton. Our recommendation is a $1,000 surety bond, stay away from all MARTA stations at this point, and no alcohol, drugs, or weapons. Thank you.
All right. PD Kim?
Yes, Your Honor. Mr. Reese is 23 years old, Your Honor, and he was going to Georgia State University. However, he's kind of like taking a leave of absence to take care of his grandfather, who is very, very ill. He is also working as a part-time manager at McDonald's. Your Honor, his financial situation is very tight. He has been full-time student, and he recently had to give up his education to take care of his grandfather. I would like to request for signature on bond. And he has been here in Georgia for all his life, and he's got his grandfather that he's taking care of. He's not going to go anywhere. He's not a flight risk. We would like to request for signature on bond for this matter. Thanks.
Okay. I'm going to order the $1,000 signature. $1,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order the stay away from the East Point MARTA station as well as all MARTA while on bond. Mr. Reese, you're not to use MARTA. You're not to go back to MARTA. You're already under suspension, so you will need to take ride shares, Ubers, cabs, or other friends to drive you around while you're on bond.
Permission to speak, ma'am?
No, I'm sure your attorney will tell you not to. Do you have a question about your bond conditions?
Yes, ma'am. I cannot pay the $1,000. That's why I want to know if I can do the signature bond.
With your history, no. I cannot give you a signature bond with your criminal history.
Yes, ma'am. I'm grateful.
All right, your attorney will explain to you what the $1,000 surety bond means, because that's a very low bond.
Yes, ma'am.
Okay, she will explain it to you.
Thank you. Everything, Judge.
All right, good luck to you.
Position 18, Washington.
This is 22 CR 008287C. Corey Washington, you're charged with one count of simple battery family violence. The offense date is 4/29/2022. Pre-trial.
11 total. You got an open battery DV in state court, cruelty in the third, 3 counts. It's 20 CR 002 595C. He got a forgery warrant out of Milledgeville, identity theft out of Winder, and a 4th-degree forgery out of Appleton, Georgia. He went to felony earlier. The cruelty in the felony case was dismissed, and he got no bond for the other felony charge. Last arrest was on the 5th of this month, Putnam County. Printing, execution, negotiating fictitious checks. December 2nd, Oconee County, forgery in the 4th. Those open cases I told you. The battery conviction, disorderly conduct conviction out of DeKalb County. He had an ag assault first offender. That was from 2014, 14 SC 131417. 2014 cruelty in the 3rd, battery DV, 2 counts, 1 count criminal trespass. Nah, it's cruelty in the 3rd, 4 counts actually, Judge. 2013 criminal attempt to commit a misdemeanor. 2009 probation trespass. 07 trespass first offender.
Your Honor, this, if I may begin.
Yes, go ahead, Deputy.
This incident happened April 29th, 2022 at 7328 Toccoa Circle in South Fulton. During what was supposed to be a custody exchange of the party's shared minor child, the defendant pushed the victim in this case, Miss Carrie, Kerry, Dagou, or Dagou, Dagou, in her chest. That was following a verbal dispute about the defendant's use of Miss Dagou's phone. I just want to kind of outline more specifically this defendant's violent history when it comes to women and when it comes to family violence. There was the October 15, 2022 open family violence battery, which we did transfer to the DA's office because of his family violence history, which made that a felony. That was a case that he received no bond on in felony court, and it was the same victim, Mr. Dagou, same set of facts. However, the victim in that case sustained cuts and bruises. Then we have the October 2020 family violence battery conviction, which is why his current family violence battery got upgraded. That was out of DeKalb, involved also Miss Terry Dagou. Then we have the 2020 family violence battery cruelty to children here in Fulton County. On that case, he FTA'd in August of 2022 and in November 29th of 2022. That was 20 CR 002595C. That is also the same victim as our case. And he currently has an open warrant on that case, and it did incur in front of multiple children, which is the cruelty to children charge. Then we go back to March 18th of 2014, where he has that family violence battery and cruelty to children out of Fulton. That involved Miss Jemina Hensley, the mother of his child. In March 22nd of 2014, he had another family violence battery that was placed on the dead docket, again involving Jemina Hensley, the mother of his child. Then we go back to November 17th of 2014, where he had an aggravated assault and cruelty to children conviction that involved the mother of his children, Miss Jemina Hensley. And in that situation, he held a knife to her in front of the victim's 4 kids. I don't think it's hyperbolic to say this defendant is a real danger to women. And as Your Honor knows, there is an increased risk of lethality when it comes to family violence battery. And with this defendant's history, he is on a trajectory that is going to cause some woman significant harm. And for those reasons, we are asking for a $5,000 cash bond. We are asking for no further contact with Ms. Dagou, Dagou, or her children. Stay away from the incident location and family violence intervention program. I just want to point out this defendant is also 6'2" and 260 pounds, and again has repeatedly battered both his children's mothers and in the presence of his children. So again, we cannot overstate the danger that this defendant presents to individuals in his immediate circle, especially the women in his life. Nothing further.
All right, PD Kim.
Yes, Your Honor. Mr. Washington is 33 years old, and he has been here in Georgia for all his life. He has one child who is 3 years old, and his child. His parents are here in Georgia, so he does have ties to the community, and yet he has not been able to have any job for last whole month. Before that, he was able to do work as an automobile technician because of his education from trade school. He has a high school diploma, and he also worked at Prime America Financial Services from 2014 as well. We believe that we would like to request for a signature on bond since he's not going anywhere because of the other felony charge. He has no bond. He will be here. So I think he should fry the bigger fish. So we would like to request for a signature on bond for this case. Thank you, Your Honor.
All right.
And Your Honor, can we sound for Ms. Carrie DeGoo? We're not able to reach her. The number we had was not in service, but I just want to sound for her out of an abundance of caution and make sure we're complying with Marcy's law.
All right, Ms. Carrie DeGoo. Carrie DeGoo. All right, don't see her on the Zoom. All right, I will go ahead and rule on this case. I'm going to issue the $5,000 cash fine. And that is because of the history that was presented today. With that $5,000 cash fine, I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a stay away from 7328 Chicova Circle. I'm going to order no further contact with the victim, Carrie DeGoo, and her children. And no drugs, alcohol, or weapons while on bond. And that's all I will order at this time. Anything else, counsel?
Nothing further from the state.
Will we be able to have a one-time visit with a law enforcement officer?
Due to the nature of what I've heard, no. I'm going to not allow him to even go back with law enforcement. I don't think he's going to be able to
No
cooperate.
third-party transfer for children either, Your Honor?
No, not gonna order that either. I don't like the history that I've heard in front of these children. I don't think he gets that privilege right now, so we'll wait till there's other future orders on that. So no, I'm not ordering or allowing any visitation. And since the mother and the children can't have any contact with them, I think it'd be contradictory to then allow third-party interaction. So I'm gonna shut all that down right now so we can make sure that the mother and the children are going to be safe.
Mr. Washington, I strongly recommend you to stay silent. This is your constitutional right you want to protect.
I do want to stay silent, but there was a lot of information that she gave that was definitely invalid and wrong as far as like the criminal history. I do have a history of some things that happened in the past, but the information that she gave as far as like from the past and who the victims were and in front of the children and stuff like that, that the information she gave was definitely false. I've never did.
Let me say this. I'm going to stop you because you're going to probably make some incriminating statements about your criminal history. And I'm sure that your attorney will tell you to hold on that. This is a bond hearing. Some of those things, if you want to correct the particulars of it, fine. But if there was anything that we stated that was not you or that was not involving you, or that we were mistaken on some of that history, then that may be relevant at this point, but it probably won't change my order of bond. But we won't entertain the correction of the factual things. But if you're telling me that some of those arrests did not occur or were not you, then that would be the only thing that I would be interested in hearing.
Yes, definitely it was not me. And a lot of the calls that was given, even with Carrie Ann Dagu, was literally just to be able to get me locked up. None of this stuff actually.
No, that's not what I said. There's some people who have had their identity stolen, or there's someone else using their identity. And if you're telling me that you don't know who any of those people are, that you have no knowledge of who they are, that those arrests did not occur or anything close to that did not occur because it wasn't you. That would be my only concern if we had the wrong criminal history on the wrong person. So that's not what you're saying, is it?
No, that's not what I'm saying.
Okay, well then I think you better, for your best interest, not speak about the facts and particulars. This is not your trial. This is your bond hearing.
Now, would I have an opportunity of coming back for a bond reduction?
You will. Your Reese to that date right now, if you don't make bond, is December the 29th. So if you don't make bond before then you will come back for a hearing again on December 29th.
And Your Honor, just to correct one thing, I did misspeak. That 2014 case was placed on the dead docket. So that was the only one. The only one we had that was not, it was incorrect about that being a conviction. The rest of his history is his. I've checked, I just went back and double checked his GCIC.
Okay, thank you. All right, that will conclude this case.
Judge, can you please repeat the bond?
The bond is $5,000 cash bond.
Position 15, Spikes.
All right. This is Gregory Spikes, case number 22 CR 008270A. You're charged with 1 count of simple battery. The offense date is 9/1/2022. Pretrial.
39 total. Last arrest was 2016. Let's see. Probation violation for shoplifting. The probation was not prosecuted. 2016 misdemeanor possession of marijuana. 2016 shoplifting conviction. Another 2016 shoplifting conviction. 2015 probation, theft by taking. Sale of marijuana, possession of cocaine with intent. 2 counts of sale of cocaine, possession of cocaine with intent, and another possession with intent. Those are all convictions, 2014 out of Baldwin County. Financial identity fraud, forgery in the 1st degree conviction from 2007. And he got more theft from 06.
All right, that's it.
Yeah, I'll leave it at that.
Okay, Deputy Falk.
So, Your Honor, and I'm going to try to get through this, as quickly as possible. September 1st, 2022, this was at the Kroger at 3030 Headland Drive. The defendant and another Kroger employee got into an argument over which chicken was better at which Kroger, and the defendant stated he liked the chicken at the other Kroger better. And based on this argument, he hit and pushed the other Kroger employee, Miss Joycia Bankston. That is JOYCEIA. BANKSTON. Ms. Bankston is here, and we would ask that she be permitted to speak under Marcy's law. The bond is currently set at $2,500. We'd ask that bond to remain as set, stay away from the location at 3030 Headland Drive, no further contact, and 1-day anger awareness.
All right. Miss, is it Joycia?
Yes, ma'am.
Would you like to address the court, Ms. Bankston?
It pretty I'm sorry. I'm about to get off work right now.
No, my question is, hold on. My question is first a yes or no. Do you wish to address the court?
Yes, ma'am.
Okay, are you on a public bus or transportation?
I'm a school bus driver now. I do not work at Kroger anymore.
What are you doing? And what are you doing?
I'm in training as for a school bus driver.
And are you driving the bus right now?
No, ma'am.
You're riding in training. But it sounds like though you're not in a confidential setting. You were scaring me first because I thought you were driving the bus.
No, ma'am. It's my sister that's driving the bus. I'm sitting all the way in the back.
Are there children on the bus?
No, ma'am.
Just you and
We
your,
done with our route today.
are you done
Yes,
with your
ma'am.
route? You and your sister and you're
Yes,
riding,
ma'am.
you're sitting in the back. Okay, I'm just making
Yes,
sure.
ma'am.
All right, so if you're willing to speak and it's confidential, then we can talk, okay? All right, so
Yes,
let
ma'am.
me swear you in first. Raise your right hand for me. Do you affirm that the
Can you see me?
Yes, I can see
Can you
you.
see me?
Yes.
Okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, so what would you like to tell me about this case, this incident?
I wasn't fine over chicken. It was it was pretty much the disrespect. He didn't have to go so far with putting his hands on me, but it was just pretty much disrespect. I said, please don't call me out my name again. And he called me out my name 2 more times, then walked up to me and put his hands on me.
So you all were co-workers and got into a
No, I
dispute.
was the worker. He was the customer. He already had a
Oh,
bad
okay.
attitude.
Okay, I got you. That is good to know. He was the customer and you were the worker. Okay.
And my apologies, Your Honor. I don't think that was clear from what we understood the warrant to say. I assume they were coworkers.
No, I
No,
understand.
ma'am, we was not co-workers.
So he is a stranger to you. Do you know him?
No, I do not. He's a stranger, a total stranger.
Okay. All right. Are you in fear of him?
No, ma'am, I'm not. I sat here and defended myself, so I'm not in no fear.
But you don't work there anymore and you've taken on a new line of work. Is that correct?
Yes, ma'am. After that incident happened, I left that job.
I think that would be a good reason. I understand. Okay. All right. Any cross-examination by Deputy Falk or PD Kim?
Nothing, Your Honor.
All right. All right, go ahead. Thank you. Mute yourself for a moment and you can still listen in, okay?
Yes, ma'am. Thank you.
All right, you're welcome. PD Kim?
Yes, Mr. Spike is 57 years old and he has been here in Georgia for 30 years. He's a single, he has never married. His parents passed away about 25 years ago. He actually receives disability check because of his disability. So he is qualified for public defender's service. So our office will continuously represent him. And his highest education was he graduated from high school. We would like to request for a signature on bond since he's not going to be qualified for any financial payment to make a bond. And yet, if Your Honor is not inclined to give him a bond, signature on bond, we would like to request for $1,000 maximum good bond. Thank you.
All right. I'm going to order the $2,500 surety bond on this case. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order Mr. Spikes to stay away from the Kroger at 3030 Hetland Drive. I'm going to order him to have no further contact with Joycia Bankston, and he is to stay away from her. No drugs, alcohol, or weapons while on bond. And I think that will be it for now. Anything else, counsel?
Nothing further from defense.
All right, thank you.
Nothing from the state.
Your Honor, I just want to ask, when is my next court date? Could you please tell me that? That's all I want to ask.
Right. If you don't make bond, your court date is December the 29th.
Okay, thank you.
All right, you're welcome.
Judge, I have a quick announcement for position 3. It's going to be a medical reset. And
Okay.
we're needed here in courtroom 2.
So that is Brittany Gibson.
Yes,
All right, medical reset till tomorrow.
yes.
All right. And are we done, Deputy?
Yep, we're completed.
Whew, long day?
Yes, it has been.
Yes, thank you. And I do have one other one, but I think Mr. Jordan's gonna tell me on, is it Nikki Ragland? That was the one you took off?
That is that case was waived by the public defender and we're ready to proceed.
Oh, it's just a waiver of appearance. Okay.
Yes.
All right, and I think that's all. Okay, that I had. Okay. All right, we'll do that case next. Thank you, Deputy. Appreciate you.
All right, you're welcome. Thank you.
All
Have a
right.
good-
You too. All right, this is the last case, 22 CR 008282A. Nikki Ragland, we have a waiver of appearance, charged with 1 count of reckless driving. The offense date is August 23rd, 2021. Pre-trial.
11 total. Last arrest was 2017. Suspended license, suspended registration. Got a battery conviction from 2010. Before that was a 06 arrest, battery / simple battery and obstruction. What else? Possession of a controlled substance, those from 02. And a suspended license from those in the 90s. That's it.
All right. Deputy Falk.
Yes, Your Honor. This incident happened back August 23rd of 2021 on Fulton Industrial Boulevard near Westlake Boulevard. According to eyewitness testimony, the defendant was driving down Fulton Industrial Boulevard at a high rate of speed and slammed into the back of an 18-wheeler trailer, the driver of which was making a lawful left turn. It was 9 p.m. at night, and per the independent eyewitness, they observed the defendant traveling at a very high rate of speed. As a result, this defendant sustained very serious injuries and was transported to Grady in critical condition because of her erratic driving, which led to this accident. It's also likely why she was not arrested at the scene, because of the severity of her injuries. I will point out that although she does not have she does have a criminal history, but we were more concerned regarding her driver's history. We were able to pull that up, and this was literally an accident waiting to happen. She was convicted of speeding in 2017, 58 and a 35. Speeding again in 2016, 56 and a 30, 2009, 93 and a 70, 2006, 70 and a 55, 2003, 89 and a 70. She also had offenses for suspended license, failure to maintain lane, improper passing, improper U-turn, driving while license withdrawn. And all of these are convictions. And as well as failure to appear in 2007, in 2017, and in 2016. So her driving history is pretty terrible. And you know, I'm very glad she is still with us. However, this driving is led directly to the incident that happened. There is a current $10,000 good bond set. We are agreeable to reducing that to a $5,000 surety bond. We are requesting a defensive driver course, and as well that she not engage in any additional traffic violations while out on bond.
And give me the amount again of the bond recommendation.
5,000. The current amount that it's set is 10.
Defensive driving course, and what was the other recommendation? That was it.
No traffic violations while out on bond.
All right, PD Kim.
Yes, Your Honor. Mr. Ragland is 51 years old. She was born and raised here in Georgia. My heart aches because of her condition. The reason that she has to agree to waiver of appearances, she cannot move well, and she's in wheelchair all the time. She has gone through almost 18 months of continuous rehabilitation in terms of physical therapy, lots of surgeries. It's a miracle that she's alive, and yet she cannot function at this point. She had a surgery on the back, neck. She owes to Grady more than $1.2 million medical bills, above all the health insurance that she used out. She served for U.S. Navy from 1996 to 2003. She was a veteran. She was discharged as an honor with honor. She has a bachelor's degree, and she had a really good job before the accident. However, ever since this accident, which was 18 months, ago. And she was known as a John Doe at the Grady Hospital because she could not remember anything. At this point, she has no recollection of what has happened to her, why this happened. She recently realized her name is Nikki Ragland, and she does not know what to do. She has no funds to pay for any kind of bond. She is actually residing with her best friend who's helping her. Without her help, she cannot go anywhere, Your Honor. So if she has to come to the court, it has to be Zoom hearing. Everything has to be Zoom, virtual. She's not able to, she's not mobile, Your Honor. And we would like to request for a signature on bond for her case. She's already more than enough for those traffic tickets. I mean, this is kind of like very, very sad tragedy that she has to go through. Thanks, Your Honor.
All right, I do understand her extensive injuries, but her driving history is terrible. And I certainly sympathize with her medical condition. And I understand that the bond right now is $10,000, and the state is requesting to reduce it to $5,000. So I will agree with that reduction of the bond to $5,000 of a surety bond for $5,000. I'm going to order when she gets out to take a defensive driving course. No drugs, alcohol, or weapons while on bond. And obviously no future traffic violations while she's on bond. I would limit her driving was a thought that came to mind, but I won't do it. Hopefully these other conditions will cause her to be a little more careful and think about what she's doing.
She's not able to drive, Your Honor. And can we have the driving defense course to be online as well? Would you please?
Yes, you can take the online one.
Thank you.
All right.
Judge, I think we're done.
Yes.
I see you next time, okay? It's been a
It's
pleasure.
not fair for you to leave before me. All right, but if you must, I think, Mr. Jordan, you want to run through them real quick. Does everyone want to reconcile, or is everybody okay given the time?
I know you guys are gonna hate me. We need to reconcile the calendar.
Okay, no, that's a strong word. We do not. We do our jobs.
Position 1 is a $5,000 surety reset SAP. Position 2 is a $2,000 surety reset SAP. Position 3 is a $150,000 surety. That case is reset further notice pending accusation or indictment. Position 4 is reset to tomorrow's SEA calendar. That's Gibson, since everybody got different calendars. And position 3 was Derrico. Position 5 is Glover. That case is a 4,000 surety reset SAP. Position 6 is Henderson. That's a 5,000 surety reset SAP. Position 7 is Lowe reset SAP, $1,000 surety. Position 8 is Manson, $20,000 surety. That was $10,000 on count 1 and $10,000 on count 2. Reset SAP. Position 9 was a plea. Position 10 is a $10,000 surety, $9,000 on count 1, $1,000 on count 2. Reset SAP. Position 11 is a $10,000 sign-on bond pretrial per judge. Reset further notice. Position 12 is a $3,000 surety, reset SAP. Position 13 is a $5,000 surety, reset SAP. Position 14, the $1,000 surety, reset SAP. I'm sorry. So position 14 was Reese, position 13 was Ragland,
Mhm.
position 12 was Pittman, position 11 was Pease. Position 10 was Maury, position 9 was McDuffie. And I think I said, oh, position 8 was Manson, position 7 was Lowe.
I think you got him.
Which one was up on? 14?
Mm.
Position 14 is a $1,000 surety, reset SAP. Position 15 was a $2,500 surety, reset SAP, that's spikes. Position 16 is Stockton, $3,000 sign-on bond jail. Position 17 is Sunbury, $5,000 sign-on bond pretrial. Position 18 is Washington and $5,000 cash bond.
That's it. Any concerns or corrections? All right, everyone, have a good afternoon or good evening, should I say? Yeah. All right, thank you, everybody. Bye-bye.